They thought Elon Musk would just accept the $3.2 million fine, pay up, and walk away. But what happened in that courtroom left even the judge speechless. It started out like any ordinary morning in courtroom 7B at the federal courthouse in Fresno, California. A light drizzle tapped the windows, clerks were sorting files, and reporters sipped coffee while fiddling with their equipment. Then the door opened, and Elon Musk walked in. No bodyguards, no legal team. Just him, in a gray suit, and a composed, unreadable expression. People looked up, intrigued, but not surprised. Musk had been ordered to appear for allegedly violating confidentiality rules during a prior legal hearing connected to one of his companies. The allegation was that he had shared restricted details during a public event. It seemed like an open and shut breach of court conduct. Presiding over the hearing was Judge Deirdre Colton, known for her strict, no-nonsense demeanor, particularly when handling high-profile individuals. She glanced briefly at Musk before returning to her notes. "Elon Musk," she began in a firm, even tone, "you are in breach of federal orders regarding sealed testimony. A $3.2 million fine is due within 14 days. There was no drama in the room. For someone like Musk, that kind of money might as well be pocket change. Yet his calm posture and lack of reaction shifted the energy subtly. "Do you understand the terms of the judgment?" the judge asked. "I do," Musk said, "but I'd like to respond." Heads turned. The man didn't bring a lawyer, yet here he was, ready to speak on his own behalf. Judge Colton raised an eyebrow. "Mr. Musk, I advise you to seek counsel before continuing." "With respect, Your Honor," Musk replied, "I believe it's appropriate I handle this personally." She paused, then gave a nod. "Proceed." Musk took a folded paper from his jacket pocket, no binder, no notes, and placed it on the table. "I'm not denying what I said publicly," he began, "but I do question whether the gag order was applicable under the specific circumstances." The courtroom grew more attentive. Musk pointed to a section in the court's prior order, noting that exceptions under federal fair use allow certain disclosures when public safety or shareholder risk is involved. He continued, saying he merely highlighted a manufacturing concern that could impact consumers. He named no individuals, cited no restricted documents, and only referenced his own observations. Judge Colton looked intrigued. "Are you claiming protection under whistleblower provisions?" "I'm stating," Musk replied, "that this fine contradicts precedent, specifically Stansfield v. U.S. Tech Holdings, 9th Circuit, 2004. His delivery wasn't flashy. It was calm and calculated. The judge remained still, then finally said, "Referencing precedent doesn't guarantee immunity. This is a federal penalty, not theory." "I understand," Musk answered. "But if the fine contradicts the framework it's based on, it's not theoretical. It's flawed." Now the mood had shifted entirely. The judge was no longer correcting a rule breaker. She was engaged in a legal debate. "Mr. Musk," she asked, "are you formally requesting a motion to dismiss?" "No, Your Honor," he said. "I'm requesting a reevaluation under Statute 1287F, Clause 4, where fines must align with the specifics of sealed orders and the intent of the disclosure." "You're serious," the judge said. "I wouldn't be here if I weren't." She ordered the transcript from the March 11th hearing and the full Stansfield ruling. Then she looked back at him. "You understand this isn't just about a fine. You're challenging judicial discretion itself." "Yes," Musk said, "because if the court can fine without limits for statements not directly restricted by a gag order, then where does that authority stop?" Reporters were already typing furiously. This was no longer about contempt. It had become something else, a pivotal moment. Musk then handed her a printed copy of the March 11th order, pointing to the clause that supported his argument. Colton read it. Her face tightened. She didn't throw out the fine. Not yet. But it was clear something had shifted. By the time court resumed after lunch, the hallway was packed. News had spread. Reporters, legal experts, and spectators filled the gallery. Musk returned, same suit, same demeanor, but his presence now carried weight. Judge Colton entered. "I've reviewed the materials," she began. "Mr. Musk, your interpretation of the exception clause and the cited precedent are accurate." A murmur passed through the room. The court acknowledges that while a violation occurred, the fine of $3.2 million exceeds the bounds set by Section 35B. The fine is reduced to a symbolic $25,000. No applause, just stunned silence. "You earned this reconsideration," the judge said, "because you were prepared, respectful, and precise." As the court adjourned, Musk remained seated. Then he calmly walked out. Not like someone who won, not like someone who lost. Just a man who made his case and let the facts speak. Outside, reporters swarmed. Headlines followed. Musk overturns court, fine with calm logic. Judge reduces penalty after self-defense stuns court. People debated. Was this genius or privilege? A performance or a principled stand? But one thing was certain. It was real. Everyone saw it unfold, and the impact had just begun.